children. Ms. Mullinax, how says the petitioner?
Petitioner is present and ready, Your Honor.
Right. And you are Amanda Franks, the respondent?
Yes, sir. Your Honor.
Are you ready to proceed this afternoon, ma'am?
Yes, Your Honor.
All right. Ms. Mullinax?
Your Honor, just for I guess expediency purposes, I did send both the court and Ms. Franks exhibits, proposed exhibits today, and I would request that Father's Exhibit 1 at this time be entered into evidence, as well as 2A through F. Those are accompanied with a business records affidavit that was filed in great excess of 15 days ago. And then 3 through 6 as well, Your Honor, for just for purposes, obviously we can have testimony on them, but for purposes of the record.
All right. Any objection, Ms. Franks, to any of those exhibits?
Yes, are those the police videos, the documentation?
Yes, ma'am.
So that should be off of my record now, and I'm unsure of why they're able to use that still. I was told that they were not able to use those.
So what is your objection?
I wouldn't like those videos to be shown.
Okay. Objection overruled. Petitioners FX1, FX2, FX2A through 2F, FX3, FX4, FX5, and FX6 are admitted. FX1 is admitted for demonstrative purposes so the court can gain an understanding of what the petitioner is requesting.
And
Ms. Mullinax, you may proceed.
I would call Keith Franks.
All right, Mr. Franks, please raise your right hand.
Yes.
And
before we get too far into this, the court's proceeding on the petitioner's first amended petition to modify parent-child relationship. Is that your understanding, Ms. Mullinax?
Yes, Your Honor, and that was filed on August 20th of 2024.
Right. All right. You may continue. Thank you.
Thank you. And how old are the children?
13, 9, and 7.
And back on October 24th of 2022, were you and Ms. Franks divorced?
Yes.
And at that time, were the parties named joint managing conservators, with Ms. Franks having the right to designate the primary residence of the children?
Yes.
And was that within Potter, Randall, Hutchinson, Gray, and Carson counties?
Yes.
Has there been a material and substantial change in circumstances at this time that you believe necessitates that you be named as sole managing conservator of the children?
Yes.
With regard to that order in October of 22, were you given a standard possession order with the elections at that time?
Originally, yes.
Okay. And since October of 2022, have you and Ms. Franks been abiding by the standard possession order?
No.
All right. Can you tell the court what the arrangement has been for visitation since October 24th of 2022?
The boys were in my possession probably 95% of the time. We tried to trade them back and forth at certain times, whenever she felt like it. The police had to be involved nearly every time. We couldn't communicate on that. It was hit or miss, and that's that. There was some altercations, and so.
Okay. And so you said you've had them about 95% of the time. Can you explain to the court how you came to have them 95% of the time?
Well, the boys were in my possession. She wouldn't come get them. It says 6 o'clock or 7 o'clock. It might be 10 or 11. It might not be any communication at all. Send random strange people to pick them up, et cetera, et cetera. Well, I say et cetera. I mean, and they've been in my possession. She just wouldn't come get them. So they were in my possession 90 to 95% of the time.
So from October 24th of 2022 until March of 2024, would you say that you had them a significant portion of the time?
Yes.
And in April of 2024, did that change?
Yes.
How did that change?
Well, in April, she quit coming to get them, and I just kept them, and there was no communication.
Well, I'm talking about April of this year.
April of this year?
Yes.
Well, let's see.
You mean of 2024?
Yes. I'm sorry, of 2024. Yes, not this year. Have you kept a calendar with
Yes,
regard? Hold on.
Oh.
With regard to the times that you've had the children and that Amanda's had the children?
Yes, I put Go ahead. I'm sorry.
Would it help refresh your memory if you were able to review that calendar?
Yes. Yes.
Your Honor, may he review his calendar?
He may. For the record, counsel, you've handed him the calendar about which he testified.
Yes.
All right.
And Your Honor, I do have that if you want me to send that to the court and to Ms. Franks.
I think that's, well, at least for the courts, it's not necessary.
Okay. Okay, so let me go ahead and ask. Did the visitation change in April of 2024?
Yes.
And how did it change?
Well, the boys were supposed to start school in Lee Forest, Texas. They missed 2 days of school. They were not enrolled. So my possession started on a Thursday. I picked the boys up.
Are we talking about April or August?
Oh, this is April.
Okay, I'm talking about April. So were they in school in LaForce in April?
Yes.
Have they always gone to school in LaForce?
Yes.
Okay, so in April of 2024, did Amanda start exercising her possession periods?
Yes, she did.
And did she tell you why that was happening in April of 2024?
No.
All right. And so after beginning in April and after April of 2024, were you getting your regular standard possession order?
Yes.
All right. Did you have summer possession?
Yes.
Do you know what dates you had summer possession?
I think it was July the 1st to the 16th. Or whatever they were. I had to write a letter before April the 1st to let her know what possession I had for the summer. And I think I asked for July the 1st to July the 17th. I think it was I'm not sure, the second part of the summer possession from 1st to July the 17th, I believe it was.
And hold on. And so after July 17th, were the children in your possession or were they in Ms. Frank's possession?
In my possession.
After July 17th?
After July 17th, no, I returned them back to her.
Okay. And so at some point in time in July, did you become aware that Ms. Franks had been arrested?
Yes.
Do you know what day that was?
I believe it was like the 29th of June, maybe.
Of June or July?
July.
And were you in possession of the children whenever Ms. Franks got arrested on July 29th?
No.
Do you have any idea where they were at that point in time?
No.
Were you concerned about their welfare?
Yes, I was concerned about their welfare.
Did Ms. Franks let you know she had been arrested?
No.
All right. And so after you found out she had been arrested, what did you do?
I called the police and did a welfare check at her residence.
All right. And with regard to your home, we talked about the kids being there 95% of the time. Who takes them to school whenever they're with you?
I do.
Have there been times when Amanda was supposed to have them and didn't pick them up from school?
Yes.
Are they supposed to ride the bus to her house when she has them?
Yes.
And has that always happened?
No.
All right. And after July 29th of 2024, did we become aware that she was using methamphetamine?
Yes.
Are you concerned about the boys' safety when they're with their mother?
Yes.
Does she have one other child that she pays child support for, is supposed to pay child support for at this time?
Yes.
And does she have visitation with that child?
I think she does, but she doesn't exercise it.
All right. How are the boys doing in school?
The boys are doing great. A's and B's. They may have a C. Football, basketball, all extracurricular activities. Ride dirt bikes. Go to church on Sunday. Everything's pretty good. Just typical boys.
And would it be correct that she hasn't seen the kids since August when there was a temporary restraining order put in place?
Yes, that's correct.
And how are they doing with not seeing their mother?
Well, the youngest one asks sometimes, can I go by mom's? I'm like, no, we can't do that. Other than that, no.
And so are you trying to take the kids away from her? Do you want her to have a relationship with her kids?
Yes, that's fine if she has a relationship.
Have you kept the boys from me before?
No, never.
You've not been charged with any felonies at all for keeping the children from me?
Yes, I have been.
Did you and Nora pull on both of my arms to grab Jason Jett out of my arms?
No,
Never?
never.
Do you drink and drive?
No, I do not.
Do you have any domestic violence charges or calls that have been put on you?
Yes, from you, yes.
And Your Honor,
No previous ones?
I would ask that she specify from October 24th of 2022 and after.
All right. You understand that?
Yes, Your Honor. Do you text me, Keith, all hours of the night and cuss me and call me horrible names on text message?
No.
So between 2020, October 2022, since our divorce was finalized, up until now, you have not sent me one foul text message, cussing me, calling me names, threatening me, anything like that?
Possibly. Not that I'm aware of. Nothing that's out of the ordinary.
So if when I'm with you and we're okay and we're getting along, I'm a good mom then. Why am I not an okay mom when we're at odds?
Well, because you're doing drugs.
Do you know that for a fact?
Yes.
Do you know that I love my kids?
Yes.
I'm done, Your Honor.
All right. Ms. Molinax.
I have no further questions for this witness.
All right. You may call your next witness.
Call Amanda Franks.
Ms. Franks, please raise your right hand.
Yes, I do, Your Honor.
You may proceed, Ms. Molinax. You can take your hand down now. Thank you.
Thank you. Please state your name.
Amanda Franks.
And you're the mother of the children in this case, is that correct?
Yes, ma'am.
Back on July 29th of 2024, you were arrested, is that right?
Correct.
What were you arrested for?
I was arrested for drug paraphernalia and open container.
And during that stop, you were questioned by Officer Sibley, is that right?
Can you elaborate?
He asked you questions about why you were using dope, is that correct?
In my opinion, he was speaking of marijuana.
Okay. And so if he specifically asked you how long you've been doing meth, you don't remember that?
I know that he did ask me that, and am I allowed to elaborate? I'm sorry.
I just need you to answer the question right now.
Okay, can you repeat it?
If he asked you how long you were doing meth, you didn't understand that to be, you understood that to be marijuana?
I don't recall.
Is there
I'm sorry.
somebody in,
Okay.
is there
I
somebody
can't.
there in the room with you?
No, there's not, but I cannot understand the question. Can you say it one more time, please? You said it twice in two different ways.
Do you remember the officer asking you how long you've been doing meth?
I don't recall the particular drug.
And Your Honor, I know that those videos are very long, but I do have about a 5-minute video that I would like to play, part of the video that I'd like to play.
All right. You may.
And I'll try to do that and share video or share screen.
Please.
Judge, I don't have to take this, do I?
No, ma'am, you do not. Madam Court Reporter, you're instructed not to write or take the video.
Thank you.
And Your Honor, okay. It would be the traffic video number 3, which is FX2C.
All right.
And it's going to start at about 51:30 and go to 56:10. And I'll try to.
And for the record, the court has those, and it was sent by your office. All of those videos were sent by your office to the court. The court has those.
Let me.
Actually, in its Dropbox, which I didn't know I had, but I do.
Well, can you see anything yet?
Yes, ma'am.
Okay. It's very strange on here, so I'm trying to figure it out. Can you see that video that's paused?
Yes.
Okay. And so I'm starting it at 51:28 right here.
Right.
Example, will you log current time from Miranda?
So, I'll tell you now,
Can you hear that or
what I
no?
do is I work all the drug related stuff. Be honest and try to help you out. So with that being said, you don't have to answer anything, but How old are you?
Judge, can you hear that?
35.
Yes.
Why
Okay.
are you smoking that?
So first off, is this gonna be on record?
What?
What I tell you now?
Well, it's not gonna help. Like it ain't gonna affect you.
No, I mean it does affect me a bit.
Go ahead.
Anyway, 3 years ago, I went to court over my child, my oldest son.
You went to court?
Yes, sir. He has a different dad. They got me on a default, like in a court case, with him. And his dad beat the hell out of me all the time. Anyway, I took him to court a second time, and my son was 13, and I lost him, and I went into just a bad depression, and so, I mean, that lasted a long time. And then I left my husband for a long time. We were together 15 years. And we had 3 boys. He was actually taking me to court for custody. So
Right now? So, listen, I'll tell you something. I am willing to work with you, but you also know you're gonna have to give up information, right? So you're going to custody battle right now with your father, and your kid's dad.
mm-hmm.
So if you go, okay. My next question: can you pass a drug test right now? No. So, but where are you getting meth from? But where are you getting meth from? But where are you getting meth from?
I'm telling you, this guy, my boyfriend, he's a veterinarian. And I don't know, he was telling me it was coke, and when I tried it, I was like, that is not. You know what I mean? Anyway, I don't know. I just, I kind of got depressed again, I guess.
How often do you use it?
Not often, I get tired a lot, because, I'm just depressed, I'm not a whip,
I get. Hey, life happens. When's the last time you used meth? Be honest.
It was yesterday or the day before.
We're past all the line. Okay. So, how many times have you used it in the last week?
Probably twice. And I'm not, and just a hit, you know what I mean? I don't do anything big.
You know where to get meth from?
I mean, sometimes.
So I should say, hey, can you go give me some meth? Would you know
No, I wouldn't know who to go to, you know what I mean? I'd have to ask around, hey, I know y'all are trying to find, but I don't know. I do know, I don't know, a guy, and I don't remember the address, but I'm sure.
He'll sell it to you?
No, not to me.
So you can't go buy meth from nobody?
No, not to me.
They won't sell it to you?
No, he gets it, I'm telling you.
Who?
Matt, my boyfriend.
Matt.
My boyfriend.
What's his name? Matt what?
Duffy.
Duffy.
No, I gotta bring him into it, do you?
I'm not.
I don't want to just jack nobody else's life up.
So he can't. So you can't go get meth. So you can't help us in any way.
No, I don't hang out with people here.
Okay.
Now, Sarah Johnson, I know her, but I don't really hang out with her. You know what I mean?
All right. Well, so you are gonna go to jail with that, okay?
Yes, sir.
For the possession of drug paraphernalia. Okay. All right. So you sit back. Oh, so when we get to the jail, they have to do a little strip search on you and everything. There's not gonna be anything else on it.
No.
Okay.
There, are we back?
Yes, ma'am.
All right. All right. Ms. Franks, you saw that video, is that correct?
I did.
And you heard him asking you about when's the last time you used meth, is that correct?
That is correct.
And the
And you
video
said-
you're talking about is FX2C.
It's 2C, yes.
an excerpt from that video.
Correct. Traffic stop 3.
All right, thank you, ma'am.
Let me get back to what I was doing. You said like yesterday or the day before, correct?
Correct.
And you told him that you had used like twice in the last week.
Correct.
And you also said that you get your meth from Matt Duffy, your boyfriend. Is that right?
I mean, obviously it's on the video, but I believe I was talking about, I thought that it was cocaine.
Okay, so you actually said, I thought it was Coke and then it wasn't, right?
I believe that it wasn't. Yes, correct.
Okay, and so you were at least trying to do cocaine, correct?
Correct.
And did you hear on the video where you said that you started using using drugs about 3 years ago when you went to court over your oldest son?
That I mean, I don't recall. No, I didn't hear that.
Okay. You talked about how he has a different
When,
dad and he defaulted you. Do you remember that?
yes, when he was talking about the drugs, I was speaking of Delta, as in marijuana products, Delta 8.
Other than when,
For the 3 years.
okay, other than when you're talking about that Matt got you what you thought was cocaine, right?
Correct.
So since July 29th of 2024, what drugs have you used?
None.
Not even Delta 8?
No, I've not used Delta 8.
Are you able to pass a hair follicle today?
I can take it. Yes, I can take a hair follicle.
And you have one other child. How old is he?
I would rather not mention him. I mean, do I have to answer that?
Yes,
Well,
ma'am.
I'm sorry.
Yes, ma'am, you have to answer the question.
He is 17.
And I'm not going to ask you any info about him. I'm just asking you for purposes of child support. So that's why it's important, okay? And so when is his birthday? And so he just turned 17. Is that correct?
Correct.
All right. So when does he graduate high school, if you know?
He will graduate when he's 18. So next year.
All right. And so do you pay child support, or are you ordered to pay child support for him at this time?
I am ordered to pay child support for him at this time.
And you don't have any other children other than the 3 in this case. Is that correct?
Correct.
Are you currently employed?
I'm not.
Where is the last place you were employed and when?
I was doing home health. I cannot remember the company's name.
And when was that?
I'm actually still hired on with them now. I just don't have any clients.
Are you paid hourly or salary or how?
It would be bi-weekly.
But right. Do you get paid by the hour or by the client, or how do you get paid?
It would be by the hour.
And so what would your hourly rate be?
It depends. It fluctuates. But I haven't been taking any clients at the moment.
What would the rate typically be?
I can't answer that. It fluctuates very, very often, ma'am.
What's the range per hour?
It's only $9 an hour.
How many, what was that? I'm sorry.
$9 an hour, Your Honor.
All right, thank you. Is that the minimum, or is that the total, or is that the max?
That would be the max, I believe.
All right.
And do you currently have the kids on Medicaid, or how are they insured?
Yes, ma'am, I do have them on Medicaid.
And so you asked Mr. Frank some questions about y'all living together. When did you live together with him after the divorce?
We lived together off and on several times. So as you know, my phone was hacked because I had emailed that to y'all. I do have proof of that as well. I went to Apple and AT&T. So I'm unable to pull any information up on that right now, or any of my evidence for that matter.
And so whenever you say y'all lived together after the divorce, was he continuously paying you child support when you say you lived together?
Yes. when I say live together, like if I worked late, this is why I didn't go and pick my children up, like he states. I didn't get off at work at the Yellow Rose, I'm sorry, until like 11 o'clock p.m. at night. So I did not feel comfortable waking my children up at his house that late to take them back to Pampa. So I would stay with him. We would go on trips together. We would do things together. I mean, he was still calling me his wife to everybody, even though we were not. And
And so you would come stay because you didn't want to pick them up.
I would come stay so I would be with my children.
And so
I didn't want to wake them up and, on a school night in the middle of like at 11 o'clock p.m. at night to take them back to Pampa. That didn't make a lot of sense to me. And that is documented as well on text message.
And you mentioned him being charged with an offense for keeping the children from you. Are you aware that that's been dismissed?
I wasn't, because I've not been notified about any court dates. All of my emails are disappearing. My phone has been hacked.
And would you agree with me that from around October 24th of 2022 up until April of 2024, that Mr. Franks had the children 95% of the time or a significant amount of time?
I disagree, ma'am.
In October of 2023, how many days did you have the kids?
I can't tell you exactly how many days that I've had the kids. I was in our court papers, it stated that Keith and I could verbally agree on things and meetings and times that the boys got to spend with them. I allowed the boys to see their dad whenever they wanted to. I tried to make everything go smoothly and correct.
So the boys wanted to stay with their dad?
At times they did, and at times they didn't.
And so what changed in April of 2024 for you to start exercising your regular visitation or your regular possession of the children?
So Keith kicks my now 13-year-old son out. He was 12 at the time, out of the house, and was verbally abusive to him, threatened to hit him, said he didn't want to come back in. And I do have the documentation on that. I don't know if I need to email that to the judge or what.
And so you're talking about Tyson, is that correct?
That is correct.
And so you started taking them and then he was getting his visitation, is that correct?
That is correct.
All right. Where were the children the night that you got arrested?
They were at my house with my sister-in-law.
And your sister-in-law being related to Keith or what is?
No, it's Sarah Knuckles. It's my brother's wife.
And then you left and you were actually going to see another guy that was about to go to prison. Is that right?
Do I have to answer that?
Yes, ma'am.
I was going to see a friend. That's correct.
And you told the officer that you were in love with him and you were going to visit him because he was going to prison, correct?
I don't recall.
And you had Smirnoff with you and you had some Delta 8 with you. Is that right?
Unopened. That is correct.
And you left your kids to go see the person, your friend, right? In the middle of the night.
My friend, yes. But my kids were safe and sound and asleep and taken care of. Correct.
I pass the witness.
Let's see, Ms. Franks, did you have anything you wanted to add?
Yes, sir. I did not have an open container on me that night. There was no proof of any of it. It was all sealed and put in bags and away. I did have Delta 8 product on me that night. It was a gummy. I was honest with the officers about that. Again, I got that off my record. I did not know besides on the video, what he said I was charged with. He waited, Officer Sibley, I believe it was, until we got to the jail to tell me that he was going to charge me with a DWI because he thought I was drunk, but wouldn't give me any test to confirm that, sir, and then ask me for my blood. I don't know if that's on record or not on the videos that you've got because I can't receive them. I would like to add that to you, sir, that Keith is he is a violent person. There are good parts of him. I'm not going to completely run him down, but Keith has problems and he's an alcoholic, sir, and my kids don't belong there. I'm willing to do whatever it takes. I don't care if that's rehab, if that's what you feel necessary. I will take every step that I need to be taking for my boys.
Anything else?
No, sir.
I have
Any
a
other
couple
witnesses?
questions.
Any other witnesses?
I have a couple more questions for her now.
All right.
Ms. Franks, you said that you had a Delta 8 gummy, but you actually on the video had a pre-rolled joint. Is that correct?
That's not correct. It was not mine. If it was there, I had a Delta gummy, and that is all.
And so if the video said you on the
I wasn't.
hold on. If you are on the video stating you have a pre-rolled Delta 8 joint, then that's not correct.
So either way, Delta product is legal. And so he didn't charge me with that because of that. And that's also on the video.
Object to non-responsive, Your Honor.
This Dane.
You talked about how Keith is very violent and he's an alcoholic, but you didn't have any problem agreeing to no contact in September until you got an attorney, right?
I'm sorry, I'm not sure what you're talking about.
We had a hearing on
First order of business is Mr. Wilson has filed a motion for withdrawal of counsel. Mr. Wilson, are you ready to proceed on that motion?
I am, Judge.
And Ms. Mullinax, are you also ready on behalf of Keith Franks?
Yes, Your Honor, we're ready.
All right. And for the record, Mr. Wilson, what's the status of Amanda Lee Franks?
Judge, she was notified of this hearing. She contacted us a couple times after we filed the motion. She contacted us yesterday by email 2 or 3 times, offering certain excuses or justifications for some of the things in our motion to withdraw, but none of those were particularly going to solve the problem. That mainly being the fact that Ms. Molnax is severely overdue some discovery. That was one of the conditions of my getting into an employment arrangement with Ms. Franks, is that I told her we had to get that stuff answered post haste. And as of the date of this hearing, I've yet to see her with any of the information requested. And that is the main reason I'm attempting to withdraw, is because I cannot represent her, obviously, if she does not answer her discovery.
Right. And you have notified her of your motion, I'm sure, right?
I have, Judge, and as the hearing that is subsequent to this hearing this morning, also the motion on the modification of temporary orders.
Ms. Mullinax, not that you really have a dog in the fight, do you have any objection to Mr. Wilson's withdrawal of counsel?
No, Your Honor.
All right, then, Mr. Wilson, I will grant your motion for withdrawal of counsel. Have you filed a proposed order?
No, I do not think we have, Judge, but we will do that directly.
All right, if you will do that post haste, then you'll be out, and you may be excused if you would like.
All right. Thank you, Judge. Y'all have a good day.
Thank you. Thank you for being here. Merry Christmas.
You too.
Now we'll take up Ms. Mullinax, the motion to compel discovery and for sanctions. Are you ready to proceed?
I'm ready to proceed, Your Honor.
All right. I don't see Ms. Franks here. She is without counsel, but you may proceed.
Your Honor, there were interrogatories, requests for production, requests for disclosure that were served on August 9th of 2024. At that time, Ms. Franks was represented by Mike Warner. Those were due on September 9th. That was the Monday after the 30 days. We contacted Mr. Warner's office to try to get the responses. In response to that, he filed a motion to withdraw. So at that time, we never received any kind of documentation or responses at all, even objections. Thereafter, if the court recalls, we had a hearing on September 25th of 2024 where Ms. Franks requested a continuance because she wanted to hire new counsel, which was Mr. Wilson. We let Mr. Wilson know that this discovery was due as well. He signed up. We asked them a couple times about the discovery. As Mr. Wilson stated a moment ago, as of today's date, we still have not received that from any attorney on behalf of Ms. Franks or Ms. Franks herself. We have. Do you want me to go ahead and go over that or the motion for additional temporary orders as well at the same time?
Go ahead. Let's go ahead with the motion for additional temporary orders.
Okay, so on September 25th, if the court recalls, the court entered temporary orders. You did not change the conservatorship for the children. You just excluded Ms. Franks from possession of the children or access because she specifically requested a continuance to hire a new attorney and stated that she would rather have an attorney than have contact with her children. We hoped to get that settled pretty quickly. However, again, she hasn't complied with the discovery request or anything else. We had this case set for a final hearing on October 10th of 2024 with mediation on October 7th. That was continued because she was hiring new counsel. We also had this set for a final hearing on December 4th of 2024 with mediation set on November 20th of 2004, which was canceled because we didn't have discovery. And because I guess she had not informed Mr. Wilson about that final hearing because she was given that notice before he was hired. We do have concerns about her not having contact with the children, but again, that was at her request. My client has exclusively had the children since before September 25th, but since that date, she's had no contact at all, and he is still paying $1,000 a month in child support based on the final decree of divorce from October 26th of 2022. So we would just request that there be an order entered stopping that payment and requiring Ms. Franks to reimburse anything beginning at the beginning of October of 2024 until now, because he's not only caring for the children, but he's paying her for him to care for the children.
All right, so ordered. That's ordered.
Okay. And with regard to the discovery, Your Honor, I'm happy to set a final hearing if she doesn't want to cooperate. However, I think that we would like to have this discovery responded to. We've tried to collect it from two different attorneys now, and she's not cooperating, Your Honor. We've had to file motions in this case. We've had to contact attorneys. We've now had to have a hearing. We'd asked for expenses and costs and attorney fees in the amount of $1,500 because of her failure to answer in this case. And we would go ahead and ask for the court to maybe set this for a final and order her to produce that documentation and answers we have by Friday on our motion. Whatever date the court would like to order is fine.
Right. And I just noted that the motion was filed on what, November the 18th, and you were graciously giving her slightly less than 30 days. So if we set this for a final hearing, we're looking at sometime in January. Is that right, Ms. Dudley?
Yes.
All right. And Ms. Mullinax, how long do you think it'll take? An hour? 30 minutes?
Probably an hour to be safe. I do have, I don't know if the court recalls, I do have some videos, at least one video that needs to be viewed by the court. And so I think that would take the longest.
All right. Then the court will grant your motion to compel discovery and for sanctions, would order that Amanda Lee Franks serve her response to request for disclosure by January, 3, 2025. That's a Friday. That she serve answers responsive to your interrogatories by January 3, 2025. That she produce documents numbers 1 through 28 in your request for production by January 3, 2025. That she is prohibited from further discovery of any case while this case is pending, of any kind while the case is pending, and that she be ordered to pay expenses of discovery and court costs of $1,500 to Keith Ross Franks. I think you can put, probably ought to be two separate orders, one for the additional temporary orders, which suspends the child supports and orders reimbursement for the child support, and then also for the discovery sanctions. And then, we can set this, for trial, I think on the 6th or 7th, but if we did that, I'm not sure that the 31st, I don't think the 31st will be here, the 6th and the 7th. So, the afternoon of Monday, the 6th, or anytime on the 7th, but, we'll set it by video conference unless you have an objection to that.
Mr. Franks, do you have any objection to us doing it by video like we're doing now?
That'd be fine. I was just curious about how we're going to present the video.
Well,
That's fine. We can figure that out, but we don't have any objection, Your Honor.
All right, then we will set this, on January 7th. Is that a Tuesday?
Yes.
All right, at 1:30?
Lana, my assistant's here. Are you on my calendar?
Yes, but you're in jury trial on that day. You're available the afternoon of the 6th.
All right, then we'll do it at 2 o'clock on Monday, January 6th.
And Judge, when are the fees, the costs due, the $1,500 to Mr. Franks from Ms. Franks?
Well, let's just set everything on January 3.
Okay.
Those will be ordered paid by January 3.
Yes, sir. And we will communicate with her via email and by certified mail. That way there's no question.
All right, and then make sure that those are reflected in the court file.
Yes, sir.
All right. Anything else?
No, Your Honor.
All right, well, we'll see you on January the 6th at 2 p.m.
Thank you.
Y'all have a Merry Christmas.
You too.
Now what do we have?
I'll see you in a bit.
We have something, don't we?
I believe it was September 25th where you told the judge you'd rather have an attorney than see your kids. Remember that?
That's not what I said. That's not what I said.
You said you would rather get an attorney than to have a hearing and be able to see your kids at that point. Is that correct?
That is not correct.
I pass the witness.
Anything else you'd like to add, Ms. Franks?
Yes, Your Honor. I needed to have counsel then. I don't have counsel because my phone has been hacked, and emails to you, emails to Jomar Wilson have been interceded on. I can prove that. Yes, I do want to see my kids. I wanted to see them then badly. I had to have an attorney. I'm sorry. I apologize.
It's all right. So you're testified you're willing to do everything you need to do?
Yes, Your Honor.
All right. Does that include taking hair follicle drug screens
Whatever is necessary, Your Honor.
and having clean drug screens before you're allowed to visit?
Yes, Your Honor.
All right. Anything else, Ms. Molinex?
Not for this witness, Your Honor, but I would like to testify to attorney fees.
All right. Please raise your right hand. Solemnly swear or affirm the testimony you're about to give and the matter now in hearing before this court will be the truth, the whole truth and nothing but the truth, so help you God.
Yes, Your Honor.
All right. You may proceed.
Thank you. My name is Erin Molinax. I'm a licensed attorney in the state of Texas. I have been licensed since November 2nd of 2007. I've been board certified in family law since December of 2022. Exhibit number 6 is a copy of my invoices. I charge $400 an hour, and I believe that's a reasonable and necessary fee. My assistant, my paralegal, she's been practicing for, I believe it's 13 years. She bills at $200 per hour. With regard to the fees in this case, as of today, before this hearing, we had incurred $6,929.24. The court did order $1,500 in fees from the motion to compel hearing, and so I would request to have that taken off. So that should be, I believe, $1,429.24, and then I would request another $400 for today's hearing. So about $6,829.24. My client had the children for a
You
significant
want to give
period,
me that number again, please?
$6,829.24.
Thank you.
I'm sorry, it's $5,829.24. I apologize. I believe it was necessary for Mr. Franks to hire an attorney, given the fact that he had the children a significant period of time. And then whenever Ms. Franks was arrested and admitted that she used methamphetamine, I believe it was necessary to keep the children safe. And I think that the fees are reasonable and necessary, Your Honor, and I would request that Ms. Franks be ordered to pay those to me at a rate as ordered by the court. Additionally, I believe that the $1,500 from the motion to compel was due on Friday, and I have not received that either. So that is why we've requested payment on a payment plan on that as well, because it has not been paid.
Ms. Franks, do you have any questions?
No, other than I am able to pay the 1,500. I do have that, and I'm able to pay that now, Your Honor.
All right. Then you'll need to go ahead and forward that to Ms. Mullinax.
Okay, and then also does that take off of the $5,829.24? Is that subtracted from that, or is that added with that?
It was subtracted from the $69.29, so it was $54.29, and then I added another $400 for today. So it was the original amount was deducted.
So the original amount, if you included the $58.29 plus $1,500, you're looking at $7,300 roughly.
Yes, and that includes the hearing for today.
If you would, for the record, if you would describe the necessity of the services that you rendered and the necessariness. I don't know if that's a word, but it is now.
Your Honor, as I stated, my client came to me for a motion to modify because he had the children and because he was paying $1,000 a month in child support and didn't believe that it was in the children's best interest for him to continue to do that. At some point, Ms. Franks hired an attorney. It was Mike Warner. We sent discovery requests. We sent those we tried to get those answered several times, and that was the motion to compel. We have prepared exhibits. We have prepared our reviewed information provided by Mr. Franks that was needed for this case, such as the possession schedules that were in place and that were used and done by them in order to prepare for the hearing, and also preparing for each hearing in this case, Your Honor, and traveling to Gray County for the hearing where Ms. Franks asked for an attorney at that point, and we had a short hearing.
All right. Any other questions, Ms. Franks, of Ms. Mullinax in regard to attorney's fees?
No, Your Honor.
All right. And you're prepared to send her the $1,500 today?
Can I do that first thing in the morning? Would that be okay?
When?
First thing in the morning.
All right. First thing in the morning. All right.
Would I be needing to mail that? How do I need to make that out?
I don't know, Ms. Mullinax, how would you like to receive it?
Do you have it in a bank account or cash, or how do you have it?
I don't have any money in my bank account right now. I'm going to have to borrow it, but I can have it to you in the morning. So how would you like me to send it to you?
So if you're going to send it, I would mail it with a cashier's check. If you end up getting it in a bank account or something, we can take a card over the phone. That's why I was asking.
Okay, that might be doable as well.
And you would just contact my office at the number on the pleadings or in my email. I can give that to you.
Can you give that to me, please? And also, my phone number has changed, and also need to give that to y'all for the record.
My office number is 806.
Okay.
All right, and I'll go ahead and award the attorney's fees in the amount of $5,829.24. Anything else, Ms. Mullinax?
I have nothing further, Your Honor. I'd rest and close.
And Ms. Franks, do you have anything else?
I need to let Keith know my phone number.
All right.
Are we on YouTube still?
Yeah,
Oh.
we'll wait until we go off to YouTube.
I can,
Let me go ahead and make my ruling on the record, and then we can go off YouTube, or you can email it to Ms. Mullinax.
I can do that.
All right, if you'll be so kind as to do that.
Yes, sure.
The court has reviewed the petitioner's FX1 exhibit, which is a summary of requested relief for modification. The court will grant that in full with the following changes, and that would be, which we've already discussed, about the geographic restriction for Ms. Franks is enjoined from removing the children from further than 75 miles of the Gray County Courthouse in Pampa, Texas. And then on your third paragraph of visitation,
If mother is positive?
if mother is positive for any substances on any hair follicle drug screen, all possession and access to the children stops immediately until a time that a 10-panel hair follicle drug screen and monitored urinalysis is provided to father and file with the court. I believe the word negative is omitted from that sentence. The way that reads, it's just all she's got to do is file a drug screen and urinalysis, and the court would order that needs to be negative
Yes, sir.
before visitation picks back up. Because then in the next paragraph, in the next sentence, you do mention a negative hair follicle. All right.
Yes, sir. Got it.
And Ms. Franks, for your information, this is primarily because you testified under oath that you're willing to do anything for your 3 children, which is honorable and an admirable thing to do. And I don't think anybody questions that you love your children. Everybody knows that's here. And so sometimes it takes extreme measures for that. So let's see, Ms. Mullinax, if you'd be so kind as to prepare an order of the court
Yes, sir.
and submit a copy to Ms. Franks.
Yes, Your Honor.
All right.
Do you have a different email address, Ms. Franks, now, or the same, since you said that?
It's different.
Okay, so just send that to me as well.
All right. All right. Good luck to both of you, and good luck to your children. They're the primary reason we're here today. We want to do what's in their best interest. We are adjourned. Thank you.
Thank you.
You are excused.